Sound of Money with Santosh Sirur.
Hello and welcome to another super special episode of my podcast, The Sound of Money. I have a wonderful guest joining in me from Mumbai. In fact, I know her for quite some time, having even worked with her in a couple of organizations. In fact, delighted to have Poonam Mirchandani, who is the Managing Director, LGT Wealth India. She heads the LGT Wealth's Planning and Family Solutions Desk. With her experience of more than 25 plus years in fiduciary and legacy planning space, Poonam works closely with family businesses, in fact, business owners, promoters, family offices, H&I professionals, where she curates tailored solutions for their personal business wealth in India. In fact, internationally as well as in India. And Poonam holds a degree in law and is a trust and estate practitioner with Society of Trust and Estate Practitioners of United Kingdom. Hi, Poonam, and welcome to my podcast. Glad to have you.
Thank you, Santosh. Thank you so much. It's always a pleasure speaking with you, and thank you for inviting me to your podcast, Sound of Money. I'm
Thanks.
so looking forward to our conversation today.
Most welcome, Poonam. It's such a different conversation, not having in office meetings and now on a Zoom in a very different, kind of a spectrum that we are on. So, Poonam, probably the first thing that comes into mind when we talk about trust, when we talk about, legacy planning, and more importantly, in today's India, right, where you have super HNIs, and it's not just about India, but a lot of families even in other countries. Then the whole question comes is about succession planning and legacy planning. What kind of changes have you seen in the last, 2.5+ decade experience that you've actually had engaging with these families?
Wow, that's a Santosh,
Loaded question.
Yeah, it is. There have been so many changes, right? But if I have to pick the top 5, according to me, would be one, the wealth creation has been exponential, right? We now see more families, Indian families, appear on the Forbes billionaire list. I was just reading up recently on the 2025 list, which has been shared, and they are around 205 billionaires from India alone, making us the third largest economic power, just behind China and US. So that's definitely one key part I would see in terms of changes that I've seen, the quantum of wealth creation itself. At the same time, what I've also seen emerge is that the family dynamics and the very fabric of families have gone through a significant change. What I mean by that, whether it is like movement of the historical joint families to the more nuclear families, or it's just emergence of concerns like marital discords, completely unheard of till a decade ago. But now it's every second family that you have a conversation goes in the same direction. Or on the third side, I would say medical advancements. The technology has increased so much that the average lifespan of an individual has grown again significantly. The fourth on my list would be Indian families are becoming global in their approach and outlook, which means that whatever planning which we would do, whether it is for investments, whether it is for their business needs, whether it's for their personal asks, everything has to have a very local outlook, a combination of a global and local, combination which is there. And last but not the least, and this is one which I always think is a dichotomy in itself, right? Because at one part, we are seeing wealth creation happening, a huge amount of wealth creation coming into play. We are seeing families becoming more international in their outlook. We are seeing protection concerns coming in. At the same time, whenever I have these conversations on succession, legacy planning, the first question I ask the family is that, hey, do you have a will in place?
True.
And it never fails to, surprise me anymore. It always comes up with the answer. 8 out of 10 times is a no.
Wow. And imagine we are talking of real huge family wealth issues, right?
Yeah.
And there's so many recent incidents where things just went completely the other way. And then you don't have a will. That's when the disputes and the feuds start.
Absolutely. So it's so important to have some format, and that's why it's such a dichotomy. At one side, you have so much things happening, and one wouldn't want that to be protected out. One wouldn't want that to go to the end desired recipient, and the answer comes up No,
No.
but
But
yes,
is it,
those are the top five ones, if
yeah,
I may
but
say
is it,
so.
yeah, absolutely, fully agree with you. But is it that when it comes to this will, creating a will, working on it, it's again also the Indian psycho, the sensitivity of the issue, the emotional piece of it, right? Where even raising that discussion, simply something like as simple as making the name, the house name of the house and the son's or the daughter's name itself is, it can really create ripples within the family. So is that some primary reason where it's like not spoken about?
So mortality concerns have always been an issue. People have
Hmm.
always felt that, hey, that if I speak about wills,
Hmm.
am I really, you know, putting the mortality issue right there up? Am I inviting mortality issues on
Hmm.
my home front?
Hmm.
But somewhere I think one will have to have that balance,
Hmm.
because the downsides of not having a proper thought through legacy and succession plan
Yeah.
is significant, right? And
Hmm.
like I said, there's so much emergence of wealth which has happened, and so much complexities which every family has. I'll
Yeah.
just give you an example here,
Hmm.
Santosh. And this is very unfortunate, even very young professional who I knew
Yeah.
in the ecosystem. And this was
Hmm.
the pandemic time
Hmm.
a couple of years ago, like very small nuclear family, a husband, wife, one child, very
Yeah.
young child,
Hmm.
must be around 5, 6 years old,
Hmm.
very young couple. He had, of course, his parents, father, mother lived there. And like pandemic really caught those issues in where people passed away at a very young age.
Yeah.
Now, this individual, he passed away uh, without leaving a will behind,
Hmm.
right?
Hmm. Yeah.
And one would think that things will, fall in place.
Yeah.
But obviously, there was a friction which was happening in the relationship between the mother-in-law and the daughter-in-law.
Hmm.
Now, just imagine here a situation that this young individual didn't even think about it, but that's what the ground reality is.
Hmm.
His home was co-owned with his father. His accounts were initially co-owned with his mother, because as Indian children, we tend to always have joint accounts with our parents, right?
Correct. Yeah.
Since it was a new marriage, they didn't think about changing the accounts and everything.
Yeah.
And unfortunately, situation happened that everything the spouse had to rely on her in-laws to get access to the wealth, which
Hmm.
becomes very tricky.
True.
And what doesn't really also help is that when one doesn't do the planning properly, and here when I say planning, I don't really talk about only wills, right?
Hmm.
Starting from the basics, which is irrespective of the quantum of wealth,
Yeah. Hmm.
Santosh, because even a 50 lakhs is a very huge sum for a set of
Of course.
individual.
Yeah.
It's and could be a pocket change for another set of individuals. So I think money, the quantum is immaterial. It
Hmm.
is what you think is important, which you want to give to your desired end recipient. So coming back to this client, this not client, but a colleague, young colleague,
Hmm.
which was there.
Hmm.
So what happened was that he had not done any plannings. He had left it in this manner,
Hmm.
and obviously there was a lot of friction for the assets to go to the from the in-laws to the wife,
Yeah.
because technically what happens is if you don't have any documentation, the personal law comes into play.
Hmm.
And for example, the majority of the Indians being Hindus, the Hindu Succession Act came into play for this family too.
Hmm.
And here, if I look at who are the class one heirs for the Hindu Succession Act,
Hmm.
it is the mother,
Hmm.
the spouse,
Hmm.
and the children
Hmm.
equally. That's one third
Wow.
each.
Hmm.
So, which would be a situation what was not intended by this young person, right?
Yeah.
He would have intended the assets to go to his wife and to his child, but
Hmm.
now the asset devolution will happen as per the law of the land.
True. Yeah.
And that's why it's so important to have a will in play, which
Hmm.
clearly documents as to what and to whom the assets should go,
Yeah.
in which form and manner.
Yeah.
The second important thing, Santosh, also is that when you do the wills, you also need to align your bank accounts, your demat
Yeah.
accounts with what you mentioned in the will.
Hmm.
Especially, I don't know whether you're aware, there have been a lot of changes which the regulator is also coming into play. So we have seen SEBI come
Hmm.
up with a notification earlier this year where they came up with a uniform law,
Hmm.
right, in terms of joint account holdings.
Yeah.
Now, effective Jan this year, if I have a joint account, say with my mother,
Hmm.
right? And in my will, I've mentioned the legal heir to be my spouse to receive the assets.
Yeah.
My spouse will have no rights to receive the assets because
Hmm.
the assets will go to the joint account holder.
Hold on. Hmm.
It's got no,
Bearing.
no
Hmm.
bearing on the nomination. It's got no bearing in terms of the mode of operations of the account. It's a uniform one, and that also not as a trustee. It goes
Yeah.
on ownership basis,
Wow.
right?
Hmm.
Like for normal, you have a nominee. It goes
Hmm.
on as a trustee, where the nominee is supposed to hand over the assets to the legal heir. So
Hmm.
again, choosing the joint account holder again becomes very important.
Hmm.
So it's just not saying that, hey, I've made a will and okay, I have done whatever is required to be done. You've done a will, which is absolutely great, but then align your will with your financial accounts, that they are also appearing to the same desired end recipient. He or she is the joint account holder.
Hmm.
Or if you don't have a joint account holder, you have a nominee. The
Yeah.
nominee is the same person who's mentioned in your will also.
Yeah.
Because today, as time progresses, the laws keep on changing.
True. Yeah.
And if one is not on top of it, it
Hmm.
creates a impact which is unintentional,
Hmm.
right?
Yeah.
So I
Yeah.
would say that from a planning perspective, this is a basic planning which is required,
Hmm.
irrespective of what wealth you have. In fact, everyone, including
Hmm.
you and me, if
Hmm.
I may ask Santosh, do you have a will? The answer
The
should
answer,
be a yes.
absolutely. And the answer is no. That's where
So
the whole thing
that's
is all about, right?
so
Yeah.
that's where it goes. So
Yeah.
the first thing you should do after this call, and we will connect separately after this,
Sure.
is get your will in place, because
Yeah.
that's a basic requirement. And not just get your will in place, but align your will with your joint accounts, with your
Hmm.
nominations, with the individual who you want the assets to go to,
True. Yeah.
right?
Yeah.
So that's a takeaway which I would say is very important from a will
Hmm.
perspective. Of course, what a will is, it's a basic document. It can be a simple one pager. You can write it in hands. You can get it prepared by a lawyer. It's a simplistic document which only says that, hey, I am the owner of this wealth,
Hmm.
and these are the end beneficiaries to whom this wealth should go.
Yeah.
You need to appoint someone which is mandatory to act as an executor of the will. The
Hmm.
executor's responsibility is to go to the authorities to do the transmission process.
Hmm.
You need to have mandatory two individuals as witnesses,
Yeah.
because tomorrow there should not be a dispute whether this will was executed properly or
Yeah.
not,
Hmm.
signed properly or not. So having an executor who will take care of the transmission process, having two witnesses, and the individual who's writing the will listing out what assets he or she wants to go
Yeah.
to a set of individual beneficiaries
Hmm.
is super important.
True.
While there are always, provisions which one can do
Hmm.
to avoid disputes, litigations, like, for example, getting witnesses who are credible, maybe your chartered accountant, maybe your doctor, maybe a lawyer, who can step up if there is a contest to say that, hey, I saw this individual, he or she was in the right frame of mind, they executed the villain before me,
Hmm.
helps. Getting it motorized for sure helps.
Yeah.
Getting it video recorded goes one more level further in terms of building that contestability mitigants.
Yeah.
And last but not the least, getting it registered with the sub-registrar's office. So these are
Yeah.
some ways where you can avoid litigations,
Yeah.
but you cannot take away the litigations. But there's a
Absolutely.
lot of mitigants which are possible, and that's what one should do
Hmm.
when doing a will out.
Yeah. So let's double click a bit more on this will, because a lot of individuals, when you talk of will, right, there is always this word about this background issues about legality, notarization, registration, and these, these tasks, if I may say so, also are one feels like a bit deterrent, right? Why should I do this? But then when it comes on you, it's terrible, right? So why is Poonam, the will an important document for the individuals and families? That's my first question. And more importantly, kind of, can you share a little more about the nuances of what kind of it constitutes a will, and what will actually happen? And I know you did articulate it very well, if one doesn't have that will.
So, Santosh, like I said, that uh, what's required in a will, it can be a simple plain piece of paper, right, in which you've written down your wishes, but it is important to avoid that kind of litigation and disputes which could come in where your personal law comes into play if you don't have a will, right?
Yeah.
Now, uh, what happens is India is a multi-state country, right?
Yeah.
Every state has a different law.
Hmm.
Uh, 9 out of 10 individuals will always have real estates which they carry in
Hmm.
their name, right?
Hmm.
Now, if I have a real estate, when I'm doing a transmission of the real estate, it's driven by the state laws which govern that.
Yeah.
So if I have to say that, look, I have a set of portfolio assets, financial assets, and I have a real estate assets. So
Hmm.
when I'm trying to do a will, it could depend upon which location you're staying in, where is your property located. So under the Indian laws, and this goes back to the presidency days, the British Empire days,
Hmm.
where they used to have this concept of presidency locations. Mumbai, Chennai, and Kolkata were considered to
Hmm.
be presidency locations. So if you have properties in these locations, the movable properties,
Hmm.
or if you're residing in these locations, when I do that simple will saying that, look, I'm the writer of the will, which is the testator or testatrix, as it is called.
Yeah.
Uh, I'm appointing ABC who will execute the will, and he or she is the executor of the will. These are my assets which I'm putting into play. This is the people to whom these assets will go.
Hmm.
And I'm signing this will in my right frame of mind. I'm sound of mind, I'm sane, so on and so forth. And I have got two witnesses who have seen me sign this will. That's
Yeah.
what you do in the will.
Hmm.
Once you've done that, and you're staying in Mumbai, right? In case a demise happens, technically the executor needs to go to the court and get
Hmm.
the probate order done for the transmission to happen. Because especially for immovable properties, portfolio investments, we spoke a couple of minutes ago, the regulators are trying to make it as simple as possible,
Yeah.
as uniform as possible. But
Hmm.
for the immovable properties, there would be a mandatory requirement to go to the authorities to get a probate of the will. Probate
Hmm.
is basically, if I may put it this way, it's an order issued by the authorities,
Yeah.
and the authorities are different depending upon which place you are. It can be the High Court, it can be a district court, or it can be your Tehsildar's office also, depending upon which, how big or small the place you are
Yeah.
staying in.
Hmm.
Who basically does what? They take the copy of the will, they call for objections, they put up a public notice saying that, hey, does anyone have any objections to this will?
Hmm.
And if there are no objections, they certify that will to be a registered copy. And that registered order is what is used by the executor to go to the sub-registrar's office, which is the
Hmm.
land registry office,
Hmm.
to get the transmission of the assets done from the deceased individual to the legal heir, whoever the legal heir is mentioned as
Okay.
a beneficiary in the will.
Hmm.
So this entire process becomes very important to ensure that the assets go to the end recipients. All right.
Yeah.
But going back to your question, what happens if one doesn't have, right?
Yeah.
So India is a law country full of multiple personal laws. We spoke about the example of the young colleague who passed away, where
Yeah.
Hindu Succession Act comes into play. So apart from Hindus, it also covers other religions like Sikhs, Jains are
Hmm.
also included in the same Hindu Succession Act. Muslims have a different law, which is the Sharia law.
Hmm.
Christians are covered by the Indian Succession Act. So each of these laws will have different provisions,
Yeah.
right?
Hmm.
Which means that if I have to get access to these assets, I have to go to the courts to
Hmm.
implement it, and B, it is also possible the assets will go to individuals who are not my desired recipients. Case
True.
in point is the example which I shared earlier,
Yeah.
where the end desired recipient probably would have been the spouse,
Hmm.
but it goes to not just the spouse, but it goes to the mother, it goes to the child
Yeah.
also,
Yeah.
right?
Hmm.
So it just becomes super complex if you don't have a will.
Hmm.
Hence the need to have the will in a very simple manner, but at
Hmm.
the same time also to bring in the nominations we spoke about.
Yeah. Yeah. So let's talk about trusts, right? So it's again an equally important entity, if I may say so. What kind of roles do trusts play in estate and succession planning? Because if one has a will, okay, is there really a need to set up a trust? That's the first question. And then how are trusts emerging in today's world where you have HNIs and super rich HNIs, And they can be very tricky when you have those conversations with, I'm sure, with your clients that you've come across. So how does one really navigate this whole process of, creating a trust?
So, Santosh, let me put it this way. There is no one size that fits all, right?
Yeah.
Similarly, succession planning is very personal to every individual family that we meet,
Yeah.
right? So it is not that trust is a solution meant for every family.
Hmm.
Usually, the solutions that we see emerge is a combination of joint accounts, nominations, wills,
Yeah.
and trust,
Hmm.
along with sometimes family charters and constitutions, depending upon the objectives of every family.
Yeah.
The objectives could be driven by maybe the quantum of the wealth which they carry.
Hmm.
It could be driven by the complexity of a ecosystem of a given family. It could be a factor that the family is multi-jurisdictional, say more and more families, one child is based in US, one is based in UK, the wealth is in India,
Yeah.
right? So the regulatory nuances that those countries have estate tax, inheritance tax laws. So it could be driven by protection, not just
Hmm.
from a regulatory change point of view, but also the marital concerns that we spoke about, because it's not possible to dictate the choice of partner anymore
Hmm.
for any family to the next generation.
Yeah.
So it could be different facets which really drive a trust
Hmm.
as a solution, right?
Hmm.
Because fortunately, a trust is a much better solution compared to a will,
Hmm.
primarily because wills come into effect post the lifetime of an individual, right?
Hmm.
For example, if I write a will today, the implementation will happen only after I pass away.
Hmm.
It won't
Yeah.
happen before that.
Yeah.
And despite all those precautions that we spoke about earlier, whether it is having credible witnesses, notarizing, videographing it, so on and so forth, right? There's still the potential of someone going to the court and the
Hmm.
court putting those assets on freeze, right, till
Hmm.
the
Yeah.
time the resolution happens,
Yeah.
which means that your intended beneficiaries are not able to access your hard-earned wealth,
True.
right?
Yeah.
So many times families look at doing a balancing act.
Hmm.
If the objectives are such, any of those ones we spoke about, the quantum, the complexities, they are now looking at going towards a trust, because
Hmm.
trust as a vehicle is a super flexible vehicle.
Hmm.
It's like a whiteboard, if I may say so,
Yeah.
where every individual writes his or her own rules
Hmm.
as to how that wealth will devolve to the
Yeah.
next generation, how the wealth will be utilized by the next generation, puts in protection mechanisms in terms of who will be entitled to the trust assets and who will not be entitled to the trust assets,
Yeah.
which flexibility actually is creating a lot of acceptability,
Hmm.
right,
Yeah.
amongst
Hmm.
Indian families today.
Yeah.
So it's not that it's a new concept, Santosh. Trusts have been there in India since 1882. Our Indian
Act
Trust
itself. Yeah.
Act
Hmm.
itself is of 1882. So
Yeah.
it is not, it's not as if it's a new concept which is there, but the way and shape in which trusts are now being accepted
Hmm.
in the industry, in the country, is I think majoritively driven by how international practices, best practices have shaped up,
Hmm.
right? Again,
Yeah.
going back to a point that Indian families are becoming very global in their outlook.
Yeah.
So they are accepting those best practices in through which how these trust structures are being created,
Hmm.
because it helps them not just ensure that the wealth goes to the next generation in the right manner,
Hmm.
but it also helps them identify the manner in which that wealth is utilized for the next generation.
Yeah.
Uh, Point in question is the exponential wealth, which we spoke at the beginning of our conversation today,
True.
right?
Yeah. Yeah.
The wealth has become so much that there could be multiple generations who survive and the wealth still would be there.
True.
Okay.
Yeah.
So, how do you ensure that the wealth is not misused in any
Hmm.
manner?
Yeah. It's crucial.
Becomes important. So the end
True.
usage of the wealth also becomes very important, which is not possible through a will.
Yeah.
So in a will, what happens is you just give those assets to the next generation and then it's upon them.
Hmm.
They may use it productively, they may use it destructively. One doesn't know that.
True. Yeah.
But in a trust,
Absolutely.
you can provide that end utilization. And that has been, again, one of the reasons where families have started accepting trust to be a good solution.
Hmm.
Uh, from a implementation perspective, of course, there are different types of trusts
Yeah.
here. There are trusts which are in nature of what is called revocable trusts. Revocable trust, I prefer calling it as a superior version of a will.
Hmm.
That's my
Yeah.
go-to line for my client conversations when I do, or the families I speak to, because like in a will where you have full control on the assets, you can change the will at any point of time, you can decide who the assets should go to.
Yeah.
uh, a revocable trust carries the same features, right?
Hmm.
Because as the creator, author of the trust, I, the wealth owner, can decide who the assets will go to. I
Hmm.
can change it at any point of time. From a taxation point of view, it's a look through to me as the author of the trust, the settlor, right?
Yeah. Hmm.
So it's not a separate taxable entity. So whatever tax planning I have done for myself at my individual level continues, even though there
Okay.
is a trust in play. So keeping all these nuances in play, it is definitely meeting whatever a will does.
Hmm.
But there's a plus plus to it. What I mean
Hmm.
by that is, apart from ensuring that whatever the will is doing, that revocable trust is doing, it also takes away the transmission concerns because the assets are already in the trust during your lifetime. It brings down the disputes and contestability piece of contents because the trust is operational during your lifetime for the last 10 years. So no one can, contest
Yeah.
on grounds which are usually grounds like, oh, the person was not in the right frame of mind,
Hmm.
or he or she was coerced. This is
Yeah.
not a genuine will. These are the things where wills become contested, right?
True.
So all those things go off immediately because this is a structure which is up and running for a very long time.
Hmm.
It has gone through multiple rounds of regulatory views and things like that. And hence, uh, revocable trust ends up being a more acceptable kind of solution for many families.
Hmm.
There's also another type of trust which is very much prevalent, which is called an irrevocable trust.
Hmm.
Now, an irrevocable trust, in a very simple manner, means is a solution where you want protection,
Yeah.
uh, from any kind of unforeseen situations.
Hmm.
But the downside for an irrevocable trust is twofold. One is that as the wealth creator, I can never benefit from that structure, right?
Okay. Yeah.
Which means that if I want to create that trust, I will need to step out as a beneficiary of the trust. It will be for
Okay.
the benefit of my family, but
Hmm.
not for me, to
Hmm.
have a proper ring fencing effect to come into play.
Yeah.
If I am a beneficiary, then the ring fencing gets diluted significantly.
Hmm.
And secondly, from a taxation point of view, it's a separate taxable entity,
Hmm.
which
Okay.
means that you and I, as individuals, get a progressive rate of income tax,
Yeah.
right?
Correct.
Up to 5 lakhs and so on and so on forth.
Yeah.
A trust doesn't get that. So if there
Hmm.
are incomes which the trust earns,
Hmm.
it is taxed at the maximum marginal rate. When I say income, I mean things like dividend income, interest income, which also for some families could create concerns.
Hmm.
Though, having said that, on the capital gains front, it's neutral, it's identical to an individual.
Hmm.
So many families do consider the taxation nuances, the control nuances before taking a decision between going for a revocable trust as compared to an irrevocable trust.
Yeah.
But the key point today is that families are actively thinking about this, Santosh, more and
Wow.
more as we
Okay.
go along,
Hmm.
apart
Hmm.
from just leaving it to the wills or just leaving it to the joint accounts or nominations. It's a combination of all of this that is really working for families today.
Yeah, yeah, which is very good, right? Considering the wealth creation in Indian families and not just the metros, but even the tier B and C is where And again, you have, as you mentioned, the cross-border challenges because lots their sons and daughters are studying abroad. In fact, some families have even moved out themselves, right? And that's where those challenges are. And I'm sure having succession planning is absolutely key for Indian families. So, Poonam, at the beginning of our conversation, you did mention about these medical advancements and Indians actually, becoming global in their outlook, as, two key changes. Any key sharings that you have, what probably implies for these Indian families today?
So, Santosh, we spoke about that how the average lifespan has increased significantly because of the medical advances that we have had. Many times, because of that, there are situations where you can live for a very long period, supported by various medical machines which are there. But more and more, I'm having conversations with families where, they're telling me that, look, if I'm not in my right sense, right, I don't want to stay hooked up to machines,
Yeah,
right? Because that's not the life I want to live. I want
true.
to live a life where I'm able to, take my own decisions. I don't want to have a life where I'm putting that emotional burden
Hmm.
of so-called pulling the plug
True.
on my loved ones, because it's
True.
a major emotional trauma they
Hmm.
go through,
Hmm.
right? I'm having conversations where families are saying that, look, just because there is so much emotional trauma, and uh, by virtue of that, they decide that no, let's extend, just
Hmm.
keep on putting that individual on a ventilator, just keep on continuing that entire process. It also results into a lot of financial outflow,
True.
right? Because
Yeah.
medical treatment is not cheap today,
Yeah.
right? So families today, Santosh, are actively taking that discussion ahead,
Hmm.
and it is helpful that the regulatory regime is also slowly but steadily going in that direction.
Hmm.
So more recently, we have had concepts of what is called living wills. These simplistically are advanced medical directives
Hmm.
which have come out. And this has come up on the backdrop of the most famous Aruna Shanbag case,
Yeah.
where the judiciary finally took a decision to give her a send off in the right
Yeah.
manner, because she
Hmm.
was hooked up to machines for a very long
Really
time.
long time. Yeah.
Yeah.
Yeah. Hmm.
So, more and more families today, when I have these conversations, they say that no, I don't want that decision to be a traumatic experience. So many families are drafting up these AMDs, Advanced
Hmm.
Medical Directives, living wills for themselves, where one can choose who the guardians will be. They're
Hmm.
called guardians.
Hmm.
Basically, they're the people who will coordinate with the medical fraternity
Hmm.
for implementing the decisions. The wishes of the individual are laid down, saying that what is the amount of actions do I want? Do I want actions which are, DNR? Whether do I have actions which are, I would prefer a palliative care of this level?
Yeah.
Do I have actions which says that, hey, if I am hooked up, and please approach two doctors, and if they say that there is nothing which can be done, don't plug me in onto ventilators, right?
True.
So those personal choices
Hmm.
with respect to your own body
Hmm.
is something which you can document it in a very clear manner
Hmm.
in a format which is called the living will or the
Hmm.
AMG.
Hmm.
And the regulatory regime is also going through a change.
Hmm.
Uh, Till couple of years ago, it was very difficult to implement it. It's not very simple today also,
Hmm.
but I hope and I am optimistic that things will become more and more simpler as there is a lot of acceptability in the
True.
ecosystem on something like this.
Yeah.
But now there is a very defined process which the Supreme Court has come across, which by which the wills can be lodged with your doctors, your hospitals, which are there, who can then take cognizance of it when
Hmm.
you come in for a medical treatment. In fact, this is something which is very prevalent internationally,
True.
but in India, it's catching up. So this is
Catching up.
one thing
Hmm.
which I see definitely going up more and more in conversations. When we have a will conversation, it will no longer be just a personal will. It will
Yeah.
be a personal will along with a living will. That's the
Absolutely.
joint combination that I see happening.
Yeah. One last question before I let you go. You know, as professionals, I'm sure you deal with clients and bills and succession planning. All that is a given. But what you're dealing with is a very sensitive issue to the family, right? And then you have, I'm sure, when you have your initial discussions and these discussions mature to an extent where you eventually end up signing up for the client, there are those motions of emotions and sensitivities around it, and families discussing amongst themselves what next and how to go about. As a professional, right, and it's like a doctor, right, it's as good as a doctor telling them, you got to sort this out, right, whatever that disease or whatever that is. But this is much more serious than what even a doctor would think of, because it's about family ties and long-term relationships. How do you kind of navigate this, when you have these discussions with clients, with your rich experience?
So no, you're so correct in that, right? It is a fiduciary role, right? You call it any fiduciary, whether it's a doctor, whether it's a lawyer. There's a lot of responsibility which one takes
Yeah,
in giving the right solutions for families. It's not an easy conversation to have. Sometimes one gauges with what kind of feedback you're getting from
true.
that individual, maybe verbal, maybe non-verbal,
Hmm.
right? So you need to be there on top of your game to understand what kind of uh, com- the silent nuances, the silent pointers which keep on coming in.
Yeah.
But I have realized that bringing out you know scenarios which have worked for other families or have not worked for other families, both sides of the coin,
Hmm.
really helps in clients understanding it in a more easier manner,
Hmm.
because then they are, you know, hearing a story about someone else,
Yeah.
right?
Yeah.
And at the
Yeah.
same time, in the background, they started relating to it,
Hmm.
right?
Correct. Yeah.
Because
Yeah.
now they can think, oh, this is something which is also possible
Hmm.
in my current ecosystem
Yeah.
also.
And
So
can
can
happen to me. It's
and
as
can
good as.
happen to me,
Hmm.
absolutely. So a, a combination of understanding the non-verbal cues along with the verbal cues, and the case studies, like we call it, right?
Yeah.
Bringing those scenarios which have worked or not worked for other families really helps us get that engagement kick-started with families.
Hmm.
Uh, of course, there are, I can go on in terms of the conversations. There have been families where there have been multiple generations sitting on one table, and we've tried to bring in a balancing act amongst the views,
Yeah.
because people tend to get very vocal when they're having this conversation. It's a very passionate subject at the end of the
True.
day, and a very emotional one too.
True.
But yes, it's always been something where I feel very happy,
Hmm.
taking away that at the end of the day, we were able to achieve a solution which was aligned with the objectives of the family. I
Hmm.
think that gives me the biggest amount of happiness that we were able to give that solution to the family, right?
Absolutely. And I'm sure you don't have come, or, you kind of, your fraternity doesn't come across those events, mere paas maa hai kind of moments, right? on, on that very, very optimistic and positive note, Poonam Mirchandani, Managing Director, LGT Wealth India, thank you so much for being with me on this podcast, The Sound of Money.
Thank you so much, Santosh. It was lovely speaking to you as always, and wishing you all the best for the future episodes of Sound of Money.
Thank you so much. And well, with that, we come to the end of this episode of The Sound of Money with me, Santosh Sirur, and my guest, Poonam Mirchandani. Thank you once again for being on this podcast. Bye and take care.
Thank you.